So we've got a lot of experience with evictions, and all sorts of things pop up on the day of trial. Sometimes you get a little bit of lead time that some crazy claim is going to surface, but not always. In this case, we had a client who was owed 3 full months of rent. He had tried working with the tenant. They had tried to see if there was something they could do, give a little extra time here, maybe wait on work to pick up over there. But over and over, it was excuse after excuse after excuse, and nothing was happening. Unfortunately, things were not getting better for this tenant. They were just getting worse. And no matter how many times my client gave a little or cut the guy some slack, the money that he was turning in wasn't gonna pay the full rent, and eventually things began to snowball. The tenant started having trouble in all sorts of other areas and couldn't keep up. Eventually, my guy was stuck, having lost 3 full months of rent and still had no clear path to any kind of recovery. That's when he came to me. And that's when we began to institute the eviction process. And yeah, it's never a fun thing to do, but when you've got 3 full months of no rent, it should be a pretty clear-cut case, and it should be pretty easy to issue that notice to vacate, walk into the court, and get your judgment. But in we walked after we had given all the proper notices. We'd heard absolutely nothing from this tenant until we got there at the time of trial. Sure enough, the court calls our case. We walk up to the bench, and up walks the defendant for the very first time. I'd never seen or heard from him before. We present our case just like we always do, and then the tenant gets an opportunity to talk. And right out of the gate, he says, "Mold." Nope, he had never made a mold claim before, but here we are for the very first time in court in front of the eviction judge, and now we're having to deal with allegations that the unit has been filled with mold for weeks, and we have done nothing about it. Have you ever had a tenant make some claim in the eviction court that you hadn't repaired this, or that they begged you to fix that? What did the judge say in response to that claim, and how did your eviction turn out? Naturally, my client was freaking out, and he wanted to jump up and down, yelling and screaming, and tell this judge that's a bunch of lies. But normally I tell my clients it's best not to say anything. Let the defendant say what they're going to say. I will question them and figure out what exactly is going on. It doesn't help for the landlord to get emotional and outburst themselves. The court likes things cool, calm, and collected. And if we can't present a concise, emotion-free case, we probably can't win. So it's always better to let the defendant say what they have to say. Remember, they've got some proof issues to have to contend with, and that's where we step in. So let's talk a little bit about how things work, particularly in the state of Texas, when someone has any kind of repair claim that they raise for the very first time in front of the eviction judge. Now, your state might vary in the way that it handles these kinds of claims. In the state of Texas, it just isn't true that due to some defect, even a big defect, that you have the absolute right to simply withhold your rent, especially for multiple months. There's simply no element in the law that allows a tenant to just say, well, I'm going to stop paying rent until you do your part, landlord. Now, that's not to say that the law doesn't emphasize a landlord's obligation, their duty to remedy certain defects on the property. However, there are specific rules to have to deal with, and those rules are extremely important. In the state of Texas, a landlord is entitled to receive some kind of notice from their tenant that something has gone wrong on the property. If we're hearing it just for the first time in the eviction court, that just isn't enough time for the landlord to have reasonably been given some reasonable amount of time to actually do something about it. Additionally, in the state of Texas, there are only certain problems that rise to the level of landlord, you really got to get this done. And so those are essentially the defects on a premises that materially affect the health or safety of an ordinary tenant. If you've got one of these and you know about it, you have a duty to resolve that defect. Your tenant shouldn't be held at risk, even if they haven't paid rent, where their health or their safety is potentially at risk of some material harm. So I always tell landlords in these situations, if you've got a big problem where someone's health or safety are materially at risk, then don't delay, don't hold out until they pay you. Go and take care of it and proceed in all other aspects with your eviction. Now that's not what happened here, because again, this is the very first time we hear this claim of mold. So naturally, my first question out of the gate is, when did you send any kind of notice of the mold to the landlord? And of course, the tenant stumbles and says, well, I told them about it, da, 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 da. Remember, we're in court, and if the tenant isn't prepared to display adequate evidence to the court, these claims probably aren't going to get very far. And I ask these questions knowing full well what the law requires in the state of Texas. But you can expect that a tenant who's desperate is going to say and do just about anything sometimes to make sure they don't get evicted. Sure, it's a sad situation, but that doesn't mean they can go and twist the facts to knock out your eviction. If you have filed an eviction and you have a legitimate claim for it, as long as you can prove that you followed the steps, you should get your eviction judgment. Now back to the tenant. This tenant made the claim that mold was suddenly all over the unit, but he had absolutely zero proof of it. He didn't even have photographs on his telephone, and he certainly didn't have proof that he gave any kind of notice to my client. As such, the judge simply disregarded it, explained to the tenant that this wouldn't serve as a valid defense for him withholding rent for 3 months. So ultimately, the truth came out, and the tenant explained how he was unable to make his rent payments, and no matter how hard he tried or how many times he and the landlord tried to work things out, he had gotten behind and now was unable to catch up. The result was an eviction in favor of my client, and there was no appeal. He was eventually able to recover his property and find another rent-paying tenant. But what if things had been a little bit different? What if in fact the tenant had given notice? What if in fact the tenant had shown up with multiple notices and photographs? Now, like I said before, in the state of Texas, this doesn't serve as a valid defense. However, if a tenant can demonstrate to the court that they gave multiple notices and continued to pay rent afterward, but the landlord was not responsive, it is possible, if we're dealing with a single month of unpaid rent, that the court may sympathize with the tenant and say, look, generally speaking, we don't use this as a defense, but you've demonstrated to me that you've given written notice multiple times and the landlord still has not responded with diligence. As such, I'm going to rebuke the landlord, deny this eviction, and make you guys work this out. Now, whether or not this is a proper interpretation of the law or a good use of the court's time is not for me to decide. What I'm telling you is, if the facts are egregious enough because the landlord has disregarded his duty despite what's going on, there are some problems that simply have to be dealt with, and a court might side with a tenant in these particular situations. So what do I advise landlords when something like this happens? Because it happens more often than you might expect. You're in the middle of an eviction and all of a sudden the tenant calls with a huge problem. The AC went out, or there's mold in the vents, or the pipe burst and now the living room is flooded. What do? Every single time, it's the same advice that I give landlords. Your number one priority in this situation is the care of your most valuable asset, that property. But you also owe a duty to your tenants. So As a method of protecting your most valuable assets, you should heed that notice from your tenant, even if it wasn't given to you in writing. Don't worry about following all the rules, just make sure you can demonstrate that you were diligent, because even though the rules might say you otherwise win, in the courtroom, that judge might have a different opinion. And so it always helps if you're able to follow up testimony that claims some defect on the property with your own testimony that says, Your Honor, I responded to that claim and I fixed it. I agree that a pipe burst. I agree that mold was found in the ventilation system. I agree that there was a problem that I fixed. In fact, I fixed it within a day or two, and here is the evidence of that repair. So don't freak out if you suspect that a tenant is going to attempt to sidestep and say, well, the reason I didn't pay rent was because there was a big problem on the property. As long as you are responding diligently to those problems, you can supply the court with your own evidence of that diligence, and you're likely to prevail. Of course, the other situation is where there really was no problem. And so when that's the case, I strongly recommend that you go out there and you document the situation. Take photographs of the sink. Shoot video of the living room and the flooding situation that was reported by the tenant, because sometimes tenants exaggerate, but if you've got evidence that contradicts their statement, again, you're likelier to prevail in the court where these fantastic allegations are presented, again, for the first time, and again, not as a valid defense. You always want to be prepared for the strongest element in your tenant's case that may end up sabotaging your eviction. If you know they're going to make claims, then be prepared to show what you have done in response to those claims. Another way to avoid these kinds of claims in the eviction court is to make it a routine to visit the property regularly. If you've seen enough of my work here on this channel, you know that I preach a 3 and a 9-month visit on the property every 12 months. The reason you're there at month 3 is because you want to see early on how your property is being taken care of. The reason you're there again on month 9 is because you want to make sure that even things started off well, they're ending well. And there's 2 really great reasons for that. Number 1, you want to keep eyes on your asset. You want to make sure that the place that you're renting out is well cared for. And when you find out that it's not, you document that evidence and you use it against a bad tenant to move them along. But when you find out that things are going well, you use that with a good tenant to keep them in place at all cost. You want good tenants to spend multiple years on your property because almost nothing is better for your property. So by having a routine inspection at least twice within any given year, you are opening that door to preserve what you hold the dearest, that property, but also you're opening the door to establish a long-term relationship with a great tenant. No, not every tenant is perfect, but there are a few out there that actually care for your property as well as you do, some even better. Understand that the game is all about who can prove the most in the best way. If you can prove all the elements of your eviction, but they can prove that you've been a lackluster landlord, not complying with basic requests for essential repairs, that's going to make your rock solid eviction look pretty bad. And you might have a judge who's willing to say, look, I don't care that all of your evidence lines up. I'm not granting this eviction because you haven't been a very good landlord. Undercut those arguments every single time with your diligence. They make a claim, you're out there. Don't just disregard them. Too many landlords just stop communicating with tenants once things go badly, right? They'll say, well, I've had so much trouble with them. I haven't spoken to them for weeks. That's when problems creep up. And that's when they're likely to make some wild allegation and can prove, because you certainly can't, prove that you were on the premises or that you responded to any of their requests. If they can show 10 texts where they begged you to come and reinstall the heat, but you said, nope, not happening, you haven't paid your rent, so that could be damning to your eviction, especially in the dead of winter when things get really cold and you look like Ebenezer Scrooge. Don't let your frustration with a non-paying tenant end up being your undoing. I get it. You don't want to be there, you don't want to face them, and you certainly don't want to go fix a house for them when they don't appreciate it by paying their rent. But I assure you, by demonstrating that diligence, you're likely going to overcome some bogus claims about repairs because you're going to have the facts on your side. If you got something out of today's video, don't hesitate to give us a like. We appreciate you doing that. Any questions or comments for us, leave those below. I respond to those myself. And if you're not a subscriber yet, click subscribe. You will not regret it. So I hope you learned a thing or two about how evictions work when they're complicated with tenant requests for repairs that suddenly pop up on the day of trial. If you're interested in learning more about landlord-tenant law, there's a video right here that YouTube seems to think is perfect for you. And until next time, landlords, happy leasing.